Any public comment? Jan and Nancy? No public comment? You satisfied with what we've done so far?
Yeah.
That's what we're gonna do anyway. Never mind so far.
I don't think there's much more that needs.
That should cover it.
I have some comment.
Mr. Riley,
You want to go through?
you want to, what comments do you have? And then we'll take a quick trip through. You may cover them all. We're not doing a lot.
Hey.
Oh, I'm sorry, Andrew Leverell.
Andrew?
Yeah,
Do you need
Get a mic.
grab a mic there.
First of all, thank you, the Bylaw Review Committee, for spending a lot of times. I know you had at least 9 meetings going over the bylaws, met with a lot of people, and just trying to update some things, also clarify some things. And I just took a look at it today, actually. I kind of wanted to stay out of the process until I saw your finished product. And just to move along really quickly, to go to your page 5 of the redlined, so we're in the animals section.
Yep,
Just a minor typo, I believe, in what is now section H, which begins in the case of revocation of said licenses.
EFGHIJK, what about it?
In there, it says, said notice to be provided set forth in section, what's it, N 7C, I believe it should now-
11-7C?
I believe it should now be 6C, because this section that it's in.
Yep.
Okay?
Okay,
So just a minor typo, but that's why we're here. Then if we move to the permit for fill, which is
yes.
chapter 49 on page 9 of your,
We're giving the jurisdiction to the planning board.
yes, which I think is a good idea, but just a couple of things I think to tweak for consistency. In the first section, where it talks about no action shall be taken on an application for a permit unless it includes, on the first bullet,
Yep,
it says the abutter list will identify all direct abutters to the property, and all abutters within 300 feet of the subject property. I think elsewhere, later in the bylaw, and also under the zoning bylaw, it uses a slightly different phrase. It says the abutters, and then the abutters to abutters within 300 feet. I think that's what you intended, so in the, that last phrase in that first bullet where it says in all abutters within 300 feet, I think it should say in all abutters to abutters within 300 feet. That's the typical notice list that a zoning hearing would utilize by statute.
And that tracks with the next
on
page.
the next page, is that phraseology correct, Sean? To the abutters and abutters to abutters? Is that what you're talking about? See,
All
in,
butters and abutters to abutters within 300 feet.
after the last bullet, the paragraph after the last bullet.
Because it's also, that same phrase appears in the next paragraph correctly.
Okay,
It says abutters and abutters to abutters within 300 feet.
Okay.
Okay? So again, just to be consistent.
okay,
And what I thought in the second bullet, you require as part of the application to have a plot plan describing the property and indicating where the property fill is to be placed. And I guess well, let me back up for a second. I think I'm trying to assume what the intent of this bylaw is. This is a bylaw that is triggered if anyone wants to bring in 100 yards of fill onto a property. And I was assuming it's mostly because it could affect topography and drainage in a negative way in some cases. So you want to be careful that if you now fill in a hole or mound an area, you might now wash water into a neighbor. Not so much, I don't think this is directly intended because of a concern about trucks, but more of the end result of the fill, although trucks is part of the application and the hearing process. So in this second bullet where it says, supply a plot plan, indicating the subject property and indicating where the property the fill is to be placed, I added, as well as existing and proposed topography of the affected area. Because I think that's what we really
okay,
want to look at.
yep.
What are you doing?
Mr. Chairman?
Let's have the word as well as,
Town council had a question.
okay,
Mr. Chairman, I think that in this section,
The only changes you made are the strike-through changes, so this is something new.
That's fine.
Yeah, I just wanted to point out that it's not something that we had talked about at all.
That's right.
Yeah.
Right. So my suggestion was to add where it says indicating where on the property the fill is to be placed, it would now be a comma, as well as existing and proposed topography of the affected area.
Okay,
And I say the affected area because if you're filling in a half acre and a 10-acre parcel, I don't think we need to have the topography of the entire parcel. We just need to know where it is that you're adding the fill. The next paragraph, and I guess this might be a question more directly to town council, it talks about, again, the notice for the public hearing would be sent by certified mail and regular mail to the people on the abutters list. DEP now allows an alternative to certified mail, and I can't remember the phrase they call it. It's like, we use it now for orders, it's cheaper than certified mail. I guess one question is, do we have to do certified mail for this? Could we just use first-class mail? Certified mail is now getting up to $4 something, per mailing. First-class mail is usually pretty reliable, it's gonna get there, and for this type of hearing, I'm not sure if certified mail is a necessary expense. But I leave that to the board to, whatever you guys think. I had it there as a question. Also, in that very same thing, in addition to sending notice out by mail, should we add in here that it also be posted on the town website?
okay. Yep,
That is not there at this time.
Mr. Chairman,
yes, Laura.
I wonder if we're referring to, are you referring to registered mail?
No, it's,
Certified or registered?
no, it's a new thing where, and I apologize, they have a little white slip now where,
Delivery.
yeah, it's, you bring the mailing notices to the post office, and they confirm, and you have the slip also with the same address as the envelope, and then they compare that, yes, you've addressed it correctly, and they stamp your receipt to show that you mailed it out to that address, and instead of charging you $4, it's like $1, or roughly $1, 89 cents or $1 per mailing. It's just an alternative way, but you can still also, if you think there's a need, present something at a hearing to say, I can guarantee you I sent these out.
Let me ask you a question. How many permits have been sought?
I don't know that this has ever been utilized.
I don't, that's,
And that's, but,
so it's much ado about nothing, all right.
and that brings up my next comment.
Okay,
Well, kind of. In general, and I don't know where to plug this in, I was trying to jot some notes in here. I think there should be, I know there's an exemption, this bylaw will not apply now to municipal projects. For example, if you're building a road or the town's doing something. I'm wondering if this permit is also a necessary permit if, for, let's say, a new roadway that has been approved under subdivision control. Because that's gonna already have a public hearing, it's gonna already have everything laid out. There's gonna be some sort of trucking and fill brought in there. I don't know that, those same abutters are gonna be notified, so I didn't know if that should be another exemption.
well, what we're saying in the next to last paragraph is that the planning board shall hereby be authorized to promulgate rules and regulations as may be necessary or desirable to implement this section, so I would, if they have an issue with it, they can address it within their rules and regulations.
I just put it up to, I don't know if they change their regulations, or that doesn't necessarily change the bylaw. The bylaw just basically says, hey, if you're expecting to bring in 100 yards of fill for your project, you have to get this additional permit. So, given that, and let's say we were to leave it alone, back in that same second paragraph where we talk about notice,
Yep,
I wanted to add a phrase, and let me say the phrase first, before I were to plug it in, but the notice, which may be combined with any notice of hearing required for site plan review or subdivision approval or other planning board hearing, public hearing. So again, what I'm saying is, this again is typically going to arise with a commercial development or subdivision control. It could happen in someone's residential backyard if they wanted to fill in a big hole in their backyard, but in most cases, and again, this has, in our memory, I don't remember when this actually got triggered by anything, but there's usually going to be some other hearing with the planning board, either for site plan review or subdivision review. I'm just saying that the notice, there doesn't have to be two separate notices, it can be a combined notice, that's all. So, that's, the abutters are given notice that there'll be a site plan review hearing and a hearing for this permit. So there's one mailing that goes out, a combined notice. Just a suggestion, I don't know, maybe it's a regulation instead of the bylaw. Again, just trying to streamline things and not confuse things, but I know you're looking at me like I'm confusing things. Turn the page 10, just a quick typo. In the first full paragraph, or I guess the second full paragraph, second line where it says, "or business organization performing services pursuant to a contact," which should be a contract. Okay? And that ends it for that section right there. Then turning the page to page 12 of your printout. In halfway down, this is about the leakage of a flammable liquid or harmful stuff on this chapter 75. Under section A, right, your
Section, so the pages.
75, what?
section 75A,
Okay.
it doesn't actually read right now. It says, upon determination of such leakage into such main conduit or line, the fire chief shall seek to provide an immediate verbal notification of such leakage to all owners of land duly licensed for such storage of gasoline or other inflammable or injurious material in the area, defined as the source of leakage in the particular main. I think what this is trying to say is if they find out there's a leak, the fire department needs to notify the property owner and the immediately surrounding area, the owners of immediately surrounding area. Is that what this is intended for? If so, I would suggest two things. One is, notice perhaps should not go to the owners, but instead to the occupants of those parcels. Because if it is something that needs immediate notification, the owner of that four-family may live out of state or in a different town. You really want to talk to the occupants who are living there and give them notice of some sort of injury, some sort of threat that's going on. So,
Well, we're trying to, we should do both because we want to make sure that we get a hold of the owners who are going to be responsible for the,
yeah, well, you have two levels. You have a immediate verbal notification to owners, and then you have further notify owners by first class and registered mail. I left that alone, but I thought the verbal notification should go to all occupants, which might also be,
go to all owners too, because the first-class mail might take a while.
yeah, if they can, owners and occupants, that's fine. And so I think it should read, you see how there's a gap in the typing there?
Yeah?
Actually, it wouldn't be plugged in there, it would be right below that. It would say, notice will go to the leakage to all owners of land duly licensed for such storage of gasoline or other flammable injurious material, and then insert, and occupants of land surrounding, and then continue with the sentence, the area defined as the source of the leakage. Which is,
Actually, Mr. Chairman,
Yeah.
I think we need to be careful, because then how would you define the area surrounding? I think that this is to, or intended to provide notice to the owner that this is happening and that it needs to stop right away.
Okay.
That's what this, this wasn't intended to address what other public safety mechanisms might be in place
Okay.
to deal with risk to occupants, and that I think can be handled under, I mean, I think the fire department and the police department would respond if there was an emergency, a
Right.
public safety emergency.
they don't need a bylaw to tell them what to
It's
do.
the owners to say, you need to stop doing what you're doing, this is what's happening, and, you know, again, I think ultimately the owner is responsible. It could be that in a apartment building, there could be a management service or
Right.
something, but I still think that this is doing something different.
Then that, if that's the case, fine. I think everything I just said is irrelevant. Which I'm sure you're pleased to hear, Mr. Buckley. Thank you for clarifying that, and that is good. So then turning to page 14 out of 16,
Which chapter?
I'm just looking up at the top, under chapter 138, this was just for, it was just suggesting, this is regarding forwarding a copy of any application for a site assignment to the Abington Town Clerk and to the Town Clerk in any abutting town. I wondered if we should also add to the town website. So a copy of the application not only go to the town clerks, but also be posted on the town website. It's where I think we're trying to use the website as a source of
It's on the town
information.
website.
What's that?
And place a copy on the town website.
Well, it says a place copy on the internet. I think we should
On
say
the
that.
town, no, it says on the town website.
We've just changed that in the last version.
All right.
So
So what-
On town
Oh,
website?
okay, well, the one that was printed up off the town website that I got, it says internet.
Okay.
All right, great, so you already made that change.
Yep.
Genius move on your part. Down the bottom of the page, under application criteria for Class 2 licenses,
Yep.
just a suggestion, right now, with your amended wording, under Part A, it says, "No license will be granted to any applicant with outstanding unpaid taxes." Just for clarification, should we say, "No license shall be granted or renewed to any applicant with outstanding unpaid taxes"? I think it's inherent, but I don't want anyone to put up an argument to say, "You already granted me this, I'm not getting a new grant, this is a renewal." No, if you didn't pay your taxes, you're not getting a grant, you're not getting a renewal.
Okay.
Just as a clarification so that the town can collect what is due to the town.
Mr. Chairman?
Yes, Lauren.
Just so that people understand, there would still need to be, the idea of whether there's unpaid taxes and fees is something really that would be determined under Chapter 40, Section 57. And that would also guide this, but I think it's fine to mention renewals. I just want to point out that there is a process for determining whether someone's taxes and fees are unpaid. It's not random.
Right. And then, my last comment, I hope, is on the bottom of page 15 of the marked-up copy, which is Section K of the same Class 2 application criteria. This is your additional wording, adding that green space shall be added,
Yep.
which I understand, and I applaud the effort, but what I think I would suggest be inserted in addition to your wording. Your wording now said, "If not required in connection with the approvals listed in the preceding sentence, there shall be submitted a plot plan that, at a minimum, integrates green space to enhance the aesthetics of the licensed premises." My thought was to, right after the word green space, it would say, and I'll continue, "Submit a plot plan that, at a minimum, integrates green space wherever reasonably possible, in the opinion of the board, to enhance the aesthetics of the licensed premises." The reason I say that, Mr. Buckley, is you made the mistake of using the word "shall." That, I shouldn't say mistake. I would,
I get nervous when he's talking about wherever reasonably possible.
well, the thing, right now, it says you shall submit a plot plan that shall integrate green space.
Yep.
And there may be existing properties out there that are paved to the sidewalk, and because of zoning laws or whatever, that because of parking spaces and parking aisle widths and building locations, they're required to have things where they are, and they can't remove any of the pavement to put in green space. So, again, wherever reasonably possible, in the opinion of the zoning board, I'm sorry, the
Board of Selectmen.
Board of Selectmen, and this is assuming that the zoning or planning process hasn't already addressed this issue. This is kind of like another chance to get more green space. That's my only thing. There may be times where it's physically impossible, or the implementation of green space would create a zoning conflict or other conflict, so I thought it should be a caveat installed.
Yes.
Mr. Chairman,
Goldberg?
I wonder if what we could do is at the end, after licensed premises, we put a comma and say, unless the licensing authority determines the same as not feasible.
Anything to establish a level of reasonableness, or, you know, I don't want to take the onus on, I don't want to make it, let's say this, easy to escape the obligation to make green space, but I also don't want it to prevent someone from getting a business permit when they can't give you green space just because of the layout of the land as it exists, you know. There is no perfect bylaw, no perfect zoning bylaw, and that's why a lot of them have these kind of, we shall and must raise flags to us attorneys, and we want to kind of.
Certainly do.
Those are my comments. Again, I applaud your work, and I thank you for your work. Most of my comments, as you heard, were just kind of more grammatical, not substantive in nature. And I'll stick with whatever you guys decide you think you should submit to town meeting.
We shall take into consideration your suggestions. Thank you for. At the the green space issue is an issue that we will address after we close the public hearing, so.
Are you gonna kind of go over a summary just for people at home of what you're changing so that?
We are. After we hear from the public, we want to keep people here too long before we go through it, but does anybody else want to have an issue? Do you want, sir, do you have? No? All right. Why don't we'll take it from the top then and go through the executive summary, which pretty much summarizes what we've done on the bylaws. And there's a couple of thoughts I had in the process of going through them again that we will talk about. Some of the major changes we have made are in the article that relates to animals. We have tried to provide for those people who have dogs and pets to give them the opportunity to avail themselves of whatever recreation they might have with a dog, but we're also trying to keep in mind the safety of the general public. And we have brought some of the changes in Article 2 relative to dogs. We have stricken the reference to adhere to the mandate that it always be on a leash and in control of a person. But the adhere does not work. For some people, adhere works, for others it does not, and it was our consideration that a leash would be preferable to what exists now in the current bylaw, so that there will be in essence a leash law in the town of Abington. And we also included some exemptions to the ability to bring dogs to anywhere in the town, and one of the two of them are of major consideration. And the first is that any concert or other public event organized and/or administered by the Abington Summer Concerts Committee will no longer be prohibited to, an owner or keeper should be prohibited from bringing a dog even under restraint to any concert or other public event, and/or administered by the Abington Summer Concerts Committee. The other venue that we decided that should be not allow dogs to come with or without a leash is the Island Grove Swimming and Recreation Area between the dates of May 15th and September 15th, and I want to talk about that a little bit before we proceed. I was at the Grove, I went through the Grove this week, and I'm not sure that we should not strike the dates.
Okay.
So that the Island Grove Swimming and Recreation Area would be one of the venues that would be prohibited from bringing a dog even under restraint into that venue. And it's a designated area in Island Grove, which is the Island Grove Swimming and Recreation Area shall be bounded by a memorial bridge at the west, Park Avenue at the east, and the main walking path at the north, and shall include the swimming pool and recreation area. So that the recreation area that the children use during the summertime and late spring and early fall, dogs will not be allowed within that swimming pool and recreation area. And the third venue that we said that an owner or keeper should be prohibited from bringing a dog is on the grounds of the Millennium Memorial Complex, which would include not only the bandstand, but the track, the rubberized all-season track. So that track and the people that use the track would not be inhibited by the presence of dogs, whether they're on a leash or not. So those are the three venues that we have stricken. The first venue, when we say any concert or other public event, may sound as though it's duplicative of the third one, the grounds of the Millennium Memorial Complex, but there are chances that the Abington Concerts Committee, Summer Concerts Committee, might have a public event elsewhere, and that's why we have written that in specifically, so that any concert or public event organized by the Abington Summer Concerts Committee, the Island Grove Swimming Pool area that I delineated, and the grounds of the Millennium Memorial Complex, an owner or keeper shall be prohibited from bringing a dog into those venues. And we did, other than that, most of the changes in the animal section are dictated by the change in the general laws. We did increase the fines for violation of the dog bylaw. We increased the fine for allowing a dog to run at large from $50 to $100, and the violation of the removal of animal waste from $25 to $50 to hopefully bring attention to those who violate this bylaw a little more readily, so that the people of the town generally can enjoy the venues in the town that many dog owners use. So that those are the major changes in the animal bylaw. Hopefully they will address the problems that have been, yes, Mr. Riley.
You want to stand again?
Yes, please.
Sorry, on the mic.
Whatever the yellow-
Two quick things about the dog. First of all, just to clarify for anyone who's listening at home, when you just said that $100 fine if you let your dog run loose, that does not apply to your own private property. Just so people don't think that that's being enacted. But going back to Island Grove and the delineation, I was curious about the days, because I think the Board of Selectmen just enacted restrictions to put up signs, and I don't believe I think that's a year-round restriction. I was just going to suggest in your verbiage where you define that, the same area that the signs define, instead of saying by the main walking path of the north,
Yep.
might I suggest you might better describe it as by the gravel access road to the north? Because I think most people consider that as a road, not a walking path, or it certainly physically looks like that.
Okay.
That's all.
Yep.
Just to change those words. Thank you.
Yeah, but the dates, after reflection, wouldn't really cover the problem, so we'll make it a year-round issue. But in general, the bylaws have been changing in non-substantive changes. The most substantive one I said was in the animal bylaw. Some of the other ones that Sean Riley already spoke to about the fill issue, we thought the jurisdiction of the planning board was more appropriate for that sort of an issue than the Board of Selectmen. We also proposed, as Attorney Riley also noted, about the green space and the Class 2 licenses. I'm not certain that we can address his issue, whether or not we can make it mandatory or not, but we will take that into consideration at the end of our public hearing. We also inserted a new bylaw chapter to formally recognize and codify the Saving Abington with Green Energy, the SAGE Committee, in an effort to promote and support sustainable energy in the town. And we added language to clarify the existing bylaw regarding the use and permitting of firearms and explosives within the town limits. As I said earlier, the remaining changes are non-substantive, addressed grammatical issues, removed obsolete provisions of language, and also gave some authority to the town clerk to make non-substantive and administrative changes to the numbering of the bylaws where necessary. We will discuss the changes that were suggested this evening and before we finish, but we would like to finish our deliberations this evening and file a report with the Board of Selectmen for inclusion on the town meeting warrant. There is also money left over in an article we had for the charter reform, about $800, which I would like to be able to utilize for the implementation, particularly as the signage relative to the dog bylaw. So we will draw up an article, ask for that money to be transferred for the purposes of implementing those changes in the bylaws suggested under the animal bylaw. You got any other thoughts, Andrew or Lauren?
No.
Nancy or Jan? Okay. We will declare the public hearing closed then, and we will deliberate upon a couple of the suggestions that Sean Riley made and proceed from there and file a report.
Okay.